Welcome back to In Your Defense. I'm Attorney Steve Toland. Today we're going to finish our conversation about your fundamental trial rights, your constitutional rights in the Sixth Amendment that are impacted by COVID. So this one we're going to focus on the Sixth Amendment right to confront and cross-examine the witnesses against you. It has been well established, going back to Roman law, English law, and now, of course, United States law, that you absolutely have the right to confront and look eye to eye and gauge the credibility face to face of your accuser or anyone offering testimony against you. Where this becomes a challenge, obviously, in the light of the pandemic, is trying to appear by video. Interestingly enough, we can look to a Texas case that was decided by the Court of Criminal Appeals. Although it's a recent decision, the decision-making occurred and the rationale behind it was all pre-COVID. So let's look at that case quickly. This was an assault case where a nurse practitioner conducted an exam, and then as a result of that exam, some physical evidence was captured. And so the state needed to introduce that physical evidence as well as the nurse practitioner's testimony. The nurse practitioner moved to Montana. Hey, wouldn't we all like to move to the mountains of Montana? She didn't want to come back to Texas and testify. So right before trial, she says, I can't come, and she gave some reasons for it. And then the trial judge, strangely enough, let in that testimony, let her appear via video. Defendant was convicted. Defendant appeals. Court of Criminal Appeals said, not so fast, my friend. And let's look at three things that were key in that decision and how you can apply those moving forward in this age of COVID. First and foremost, the Court of Criminal Appeals was a little perturbed that the attorney did not subpoena that witness. So if you are facing criminal justice, a situation right now, you're in court, make sure your attorney subpoenas all your witnesses. Number two, second important thing to remember is that you need to continually assert your right to a speedy trial. I know there's an executive order. I know there's gubernatorial orders that sort of toll or suspend in light of the pandemic. But you need to let your attorney know, Mr. or Mrs. Attorney, please continue to assert my rights to a speedy trial. I don't want to agree to anything. I don't want to look like a jerk, but I need to continue to assert those rights. Third and most important thing, I think, in light of your Confrontation Clause rights, is you're going to need to challenge the reasons why a witness says they can't come. So that, again, can make you look like a jerk, but if other people are in the courtroom risking exposure to the virus, etc., what safety procedures are they adopting? Face masks, 6 feet or more separation. What, in other words, can you do to make it safe but stay in the courtroom and still have your live confrontation? So if others are in the courtroom, what are they doing? And then you would just assert and challenge and say to the judge, hey, Judge, I think we can fashion some remedy here where we can still protect and maintain our Sixth Amendment rights. Those rights are so fundamental to a fair trial. You need to have an experienced attorney who knows how to assert those rights and apply facts and arguments that will help support you. If you have any questions about this, please reach out to me, Attorney Steve Toland, or us here at Peek & Toland. We're always glad to help.